New York City has spent over $12 billion on migrant services since 2022, and that number keeps climbing. But here's what nobody is telling you. That spending is directly hitting your wallet, your neighborhood, and your rights as a New York resident. Property taxes are rising. Landlords are getting pressured into city contracts they don't fully understand. Tenants are watching their buildings change overnight. Drivers are sharing roads with unlicensed operators, and longtime residents feel like the system that was supposed to protect them is being stretched to its breaking point. This video breaks down exactly what's happening, fact by fact, law by law. Number one, the $12 billion price tag. Where is your money actually going? Let's start with the number itself, because $12 billion is not an abstraction. That is real taxpayer money, your money, being spent by New York City on what the Adams and Hochul administrations have called the asylum seeker humanitarian response. According to the New York City Office of Management and Budget, the city's migrant-related spending reached approximately $4.3 billion in fiscal year 2024 alone. That single-year figure rivals the entire annual budget of many U.S. cities. The cumulative total from fiscal year 2022 through fiscal year 2025 projections now exceeds $12 billion, making it the largest municipal humanitarian spending event in New York City history. So where does the money go? The biggest chunk, roughly 60%, goes to shelter operations. New York City is legally obligated under the 1981 Callahan v. Carey consent decree to provide shelter to anyone who requests it. That right to shelter, unique to New York City, applies to all people regardless of immigration status. The city contracts out shelter management to private vendors, many of whom charge daily rates between $180 and $380 per person per night at facilities ranging from converted hotels to massive tent structures like the one at Floyd Bennett Field in Brooklyn. The remaining funds cover healthcare services through NYC Health and Hospitals, education enrollment under the McKinney-Vento Homeless Assistance Act, which requires schools to enroll children regardless of documentation, legal services, food, transportation, and administrative costs. Here is the direct legal mechanism that locks in this spending. Local Law 37 of 2011 and subsequent administrative directives require the city to maintain a right to shelter obligation. The city cannot simply close the door, regardless of how many people arrive or how high costs climb. What this means for you as a taxpayer is that this spending is structurally mandated. It will not stop without either a court order modifying Callahan v. Carey or a dramatic policy shift at the state and federal level. Meanwhile, Governor Hochul has repeatedly called on the federal government for reimbursement. As of early 2025, federal reimbursement has covered only a fraction of the total expenditure, leaving New York City and state residents absorbing most of the cost. Number two, property taxes and your rent, the direct connection New Yorkers aren't seeing. New York City's property tax rate is governed by the New York City Administrative Code, Title 11. The city's property tax system operates on 4 classes, and Class 2, which covers residential buildings with more than 3 units, is where most renters and landlords feel the squeeze. When the city faces a multi-billion-dollar budget shortfall driven by emergency spending, it has limited options: cut services, borrow, or raise revenue. New York City's debt service payments have increased significantly as the city issued bonds to cover emergency expenditures. According to the NYC Comptroller's Office, debt service costs in the FY 2025 budget reached approximately $8.7 billion, the highest in city history. For property owners, higher debt service and increased city spending translate into pressure to raise assessed values or maintain high tax rates. Under New York City's property tax rules, landlords in rent-stabilized buildings can apply for rent increases tied to major capital improvements under the Rent Guidelines Board process. But they can also pass through actual operating cost increases, including property tax increases, to tenants through what is known as a tax surcharge. Here is the specific law that affects rent-stabilized tenants. Under the New York State Rent Stabilization Law, codified in the New York City Administrative Code, Section 26-511, and enforced by the New York State Division of Housing and Community Renewal, DHCR, landlords in rent-stabilized buildings are permitted to increase rent by a percentage approved by the NYC Rent Guidelines Board each year. For lease renewals beginning October 1st, 2024 through September 30th, 2025, the Rent Guidelines Board approved increases of 2.75% for one-year leases and 5.25% for two-year leases. These increases are influenced by operating costs, and operating costs for landlords include property taxes. When property taxes rise because the city needs revenue, those increases feed directly into future Rent Guidelines Board decisions. This is the chain. Emergency spending increases debt. Debt increases tax pressure. Tax pressure increases operating costs. Operating costs justify higher rent increases. Every link in that chain costs you money. If you are a rent-stabilized tenant, you can verify your legal rent and look up any improper rent increases by filing a complaint with DHCR using Form RA-89. If a landlord charges you above the legal regulated rent, you may be entitled to a rent overcharge going back 6 years under the Housing Stability and Tenant Protection Act of 2019. Number 3, city contracts with landlords. What property owners need to know before signing. One significant way New York City has expanded shelter capacity is by contracting directly with private landlords and building owners to use their properties as emergency housing facilities. If you own property in New York City and you've been approached about these contracts, or if you're considering one, there are things you must know before you sign anything. The city primarily contracts through the Department of Homeless Services, DHS, and the Mayor's Office of Immigrant Affairs, MOIA. These contracts often offer landlords guaranteed monthly payments, sometimes at rates that appear above market rent. On the surface, this can look attractive, especially for landlords struggling with vacancies. But here's what those contracts can do to your property rights. Once your building is classified as a shelter or emergency housing facility, it is subject to inspection and compliance requirements under New York State Social Services Law, Section 461, and NYC Administrative Code, Title 28. Your building must meet the fire and safety standards of the NYC Building Code, which may require you to make capital improvements at your own expense before or during the contract period. More critically, there are exit complications. Contracts with the city for shelter use can create legal ambiguity about the future use of the building. Tenants placed by the city in your building may acquire rights under New York real property law. Specifically, under RPL Section 226-B, any occupant who has been in lawful possession of a dwelling unit for a period of time may have the right to renewal or may dispute removal through housing court. Some landlords who entered city shelter contracts discovered that removing occupants at the end of the contract period required formal eviction proceedings, a process governed by the New York Real Property Actions and Proceedings Law, RPAPL, Article 7. Under RPAPL Section 711, a landlord may bring a holdover proceeding against an occupant who has no right to continued possession. But in housing court, occupants, even those placed temporarily by the city, have procedural rights, including the right to an attorney under New York City's Universal Access to Counsel Law, Local Law 136 of 2017, which guarantees free legal representation to low-income tenants in eviction proceedings. If you are a landlord and you want to take back your building after a city contract ends, you need to start that process carefully and with proper legal counsel. Filing a notice of petition and petition under RPAPL Section 731 is required to start formal proceedings. You cannot simply change the locks or remove occupants. Doing so constitutes illegal lockout under NYC Administrative Code Section 26-521 and exposes you to civil and criminal liability. Number 4. Housing court is overwhelmed, and that hurts both tenants and landlords. New York City Housing Court handles approximately 200,000 cases per year in normal times. Since 2022, case volumes have increased significantly as migrant housing disputes, eviction cases backed up from the COVID-19 moratorium, and new shelter-related disputes have flooded the system. New York City Civil Court Act Article 2-A governs housing court jurisdiction. The court has jurisdiction over housing cases in all 5 boroughs, and cases are heard in borough-specific courthouses: 111 Center Street in Manhattan, 141 Livingston Street in Brooklyn, 1118 Sheridan Avenue in the Bronx, 89-17 Sutphin Boulevard in Queens, and 67 Targhee Street in Staten Island. The backlog means that if you are a landlord trying to recover possession of your unit through a holdover or non-payment proceeding, your case may sit in the system for months. Under RPAPL Section 745, a landlord who wins a non-payment case is entitled to a judgment of possession and a warrant of eviction. But even after getting the warrant, execution is handled by city marshals, and marshal schedules are backed up too. For tenants, the backlog cuts differently. If you are facing eviction and you qualify for free legal representation under Local Law 136 of 2017, you can contact Legal Aid Society, the Legal Services NYC Network, or the NYC Right to Counsel hotline at 212-962-4795. Having an attorney dramatically increases your chances of staying in your home. Studies from the Office of Court Administration showed that represented tenants in NYC Housing Court achieved favorable outcomes, meaning no eviction, in over 80% of cases, compared to far lower rates for unrepresented tenants. The system is under strain. If you have a housing court matter, whether you are a landlord or tenant, do not wait. File early, respond to notices immediately, and get legal help as soon as possible. Missing a housing court date results in a default judgment, and reversing a default requires a motion under CPLR Section 5015 showing excusable neglect and a meritorious defense or claim. Number 5, the unlicensed driver problem, what New York traffic law says and why it matters to you. One issue that has generated significant public frustration involves the large number of recently arrived migrants operating vehicles, delivery bikes, and e-scooters, sometimes without a valid New York State driver's license or any license at all. Here's the law as it stands. Under New York Vehicle and Traffic Law, VTL, Section 509, operating a motor vehicle without a valid license is a traffic infraction for a first offense, punishable by a fine of $75 to $300. A second offense within 18 months is a misdemeanor under VTL Section 509-CC, punishable by a fine up to $500 and up to 15 days in jail. Operating while your license is suspended or revoked under VTL Section 511 is a misdemeanor on the first offense, escalating to a Class E felony for repeat offenses. In 2022, New York State enacted legislation allowing undocumented immigrants to obtain a standard New York State driver's license under what is commonly known as the Green Light Law, codified in Vehicle and Traffic Law, Sections 490 and 502. This law allows individuals without Social Security numbers to apply for a standard driver's license using alternative identity documents such as a foreign passport, a foreign driver's license, or a consular identification card. The Green Light Law means that any person, regardless of immigration status, can legally obtain a New York State driver's license if they pass the written knowledge test, the road test, and meet vision requirements. There is no excuse for operating a vehicle unlicensed in New York State when this pathway exists. For New York drivers who are hit by an unlicensed driver, your options depend on whether the other driver had insurance. New York State requires all registered vehicles to carry minimum liability insurance under VTL Section 312 and Insurance Law Section 3420. Minimum coverage in New York is $25,000 per person and $50,000 per accident for bodily injury. If the at-fault driver had no insurance, New York's Motor Vehicle Accident Indemnification Corporation, MVAIC, can cover claims by innocent victims of uninsured or hit-and-run drivers. You can file an MVAIC claim by contacting them at 212-791-9100 or through mvaic.com. If you are injured by an unlicensed, uninsured driver, you may also pursue a personal injury lawsuit in New York Supreme Court under CPLR Article 16 and the New York No-Fault Insurance Law Framework. New York is a no-fault state under Insurance Law Article 51, meaning your own insurance pays for your medical expenses up to $50,000 regardless of fault, but you can step outside no fault and sue for serious injuries as defined under Insurance Law Section 5102D, which includes significant disfigurement, bone fracture, and serious limitation of use of a body function. Number 6, tenant protections that apply to everyone, including migrants, and what that means for the housing market. This section is important because many New York residents misunderstand who is protected under New York tenant law, and that misunderstanding creates frustration and sometimes illegal landlord behavior. Under New York real property law and the NYC Administrative Code, tenant protections apply to lawful occupants regardless of immigration status. If a person is in a residential unit with the landlord's permission and paying rent, they are a tenant under New York law, period. Immigration status is legally irrelevant to tenancy rights in New York City. This means that a migrant placed in a housing unit by the city or a nonprofit organization and paying rent, even if the payer is a city agency, has the same basic rights under the warranty of habitability, real property law, Section 235B, The right to heat and hot water, NYC Administrative Code Section 27-2029, requiring heat from October 1st through May 31st with indoor temperature standards of 68 degrees when outdoor temperature drops below 55 degrees during the day, and protection from illegal eviction under NYC Administrative Code Section 26-521. For longtime tenants in rent-stabilized or rent-controlled buildings, this can feel threatening when new occupants arrive in their building through city contracts. Your protections do not change. Your rent stabilization status is attached to your unit, not to your neighbors. If a landlord attempts to destabilize your unit or harass you because of changes in the building, that is tenant harassment under NYC Administrative Code Section 27-2005. You can file a harassment complaint with DHCR or bring a claim in housing court under RPA-PL Section 768, which prohibits harassment that interferes with the tenant's occupancy. Landlords who deliberately make conditions unbearable to force out tenants in the hopes of converting units for more profitable city contracts or other uses face both civil and criminal liability. Under New York penal law, Section 241.05, tenant harassment is a Class B misdemeanor. The NYC Mayor's Office to Protect Tenants also maintains a hotline where you can report harassment at 311. Number 7, what New York's emergency powers mean for residents and property rights. Governor Hochul has repeatedly used emergency executive powers related to the migrant crisis, and those powers have real implications for property owners and residents. Under New York Executive Law, Section 29A, the governor may issue executive orders suspending existing laws or regulations for up to 30 days at a time in response to a declared disaster emergency. Governor Hochul declared a disaster emergency related to the migrant influx, which has allowed state agencies to bypass certain procurement rules and expedite contracts for shelter services. For property owners, this matters because the state has used emergency powers to fast-track the siting of shelter facilities in neighborhoods without the usual public review processes required under the City Environmental Quality Review, CEQR, and Uniform Land Use Review Procedure, ULURP, under New York City Charter, Section 197C. In plain terms, a large emergency shelter can appear in your neighborhood without the community board votes, public hearings, and environmental reviews that would normally be required for a facility of that size. If you are a property owner or resident near a proposed emergency shelter site, you still have legal avenues. You can file a comment with your local community board. You can challenge a siting decision through an Article 78 proceeding under CPLR Article 78 if you believe a state agency acted arbitrarily, capriciously, or outside its legal authority. Article 78 proceedings must generally be brought within 4 months of the final agency action. Additionally, local zoning laws still apply even during declared emergencies unless specifically suspended by executive order. New York City Zoning Resolution Section 12-10 governs use classifications. Emergency shelters are typically classified as community facilities. If a proposed facility would violate the applicable use district zoning, for example, placing a community facility in a zone that does not permit it, you may have grounds for a zoning challenge through the Board of Standards and Appeals or through Article 78. The key is to act fast. Emergency siting decisions move quickly, and legal challenges need to be filed before facilities become operational to have the most practical impact. Number 8, what comes next? Federal law, state politics, and what New York residents can do right now. Understanding where this crisis goes legally requires understanding the federal framework that shapes everything happening at the state and city level. Immigration enforcement in the United States is governed by federal law, specifically the Immigration and Nationality Act, INA, codified at 8 U.S.C. Chapter 12. States and cities cannot create their own immigration law, but they can, and New York has, adopted policies that limit local cooperation with federal immigration enforcement. New York City's so-called sanctuary city policy is codified in NYC Administrative Code Section 9-131, which prohibits city agencies and employees, including the NYPD, from providing civil immigration enforcement assistance to federal agencies except in limited circumstances involving serious criminal convictions. This law has been upheld in federal court multiple times, most recently in litigation arising from Trump administration attempts to condition federal funding on sanctuary policy changes. In 2025, the Trump administration renewed aggressive efforts to challenge sanctuary policies through executive orders and funding threats. Under 8 U.S.C. Section 1373, federal law prohibits local governments from restricting their officials from sharing immigration status information with federal authorities. But courts have repeatedly found that this does not require active local enforcement cooperation. The legal battle between federal immigration enforcement priorities and New York's sanctuary framework is ongoing, and its outcome will directly affect how many people remain in New York, how long shelter obligations continue, and what cost the city continues to bear. For New York residents who want to take action right now, here's what is available to you under existing law. First, you can contact your city council representative and demand a full accounting of shelter contracts under New York's Freedom of Information Law, FOIL, codified in Public Officers Law, Article 6. Any New York resident can submit a FOIL request to any city agency, including the Department of Homeless Services, requesting copies of shelter contracts, vendor payments, and inspection records. Agencies must respond within 5 business days acknowledging the request and provide records within 20 business days or state a reason for delay. Second, if you are a tenant experiencing illegal rent increases, file a rent overcharge complaint with DHCR immediately. Do not wait. Under the Housing Stability and Tenant Protection Act of 2019, the look-back period for overcharges is 6 years, and landlords found guilty of willful overcharges can be required to pay treble damages, 3 times the overcharge amount, back to you. Third, if you are a landlord who has been approached about a city shelter contract, demand a full copy of the proposed agreement, have it reviewed by a real estate attorney before signing, and clarify in writing what happens to your property and any occupants at the end of the contract term. Fourth, if you are a driver who has been in an accident with an uninsured or unlicensed driver, contact MVAIC immediately and document everything: photos, police report number, and witness contact information. New York has a 30-day deadline for reporting to MVAIC after the accident, so do not delay. Fifth, stay engaged in the political and legal process. The Callahan v. Carey consent decree, the legal obligation underlying all this spending, has been the subject of attempted modification before. If political will exists in Albany and City Hall to seek a modification of that decree, public pressure and organized advocacy can move that process faster. New York is at a turning point, and the decisions being made right now in Albany, City Hall, and federal court will shape your rent, your taxes, your neighborhood, and your rights for the next decade. You now know the actual statutes, the real legal mechanisms, and the specific steps you can take to protect yourself. Knowledge is the only tool that actually works in this city. This video gave you information you can use. Hit that like button right now. It helps this channel reach more New Yorkers who need these facts. Subscribe if you are not already, because we break down New York law in plain language every week. Drop your questions or your situation in the comments below. We read them and we respond. Now you know your rights. Use them.